Hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we are going to talk about wills, because you will it. Is that right?
If you will it, it will become.
Yes, it is my will that we talk about wills.
Perfect.
So, actually, what is a will? I think we need to start off with that because it's a word that's thrown around quite a bit, and yet, does anybody really know what a will is? What kind of wills are there?
Oh, there's many types of wills, aren't there?
Yes.
No, I mean, you're 100% right. Not only do not a lot of people know exactly what wills do, I mean, the amount of music I listen to where artists will be like, oh, I'm leaving you out of the will. And I'm like, you've got millions of dollars. You don't have just a will, please. So yeah, I mean, a will is one of those words that everybody knows what it is, but nobody has to really dive deep into it. So let's talk a little bit about what exactly a will is and what it actually does. So number one, at its core, all a will really does is it names who gets your stuff and who's in charge.
Now, does that have to be in writing, or is there such a thing as an oral will?
In the state of Wisconsin, it has to be in writing. I don't know if oral wills are allowed in other states.
They are.
That's interesting.
Fact. Except for, how could you ever prove it? It's a little bit odd to me. It's probably antiquated.
Yeah, and there's also something called a holographic will. Do you remember those from law school?
Yeah, what is that?
Holographic will is if I just wrote down, I'm giving all my stuff to Kirsten, signed Matt.
Oh.
Just one of those handwritten deathbed wills. They're called holographic wills. I don't know why they're called holographic wills. State of Wisconsin does not recognize a holographic will, but other states may.
So fundamentally, a will is something that says, here's who I want to receive my stuff after I pass away. And what is your stuff? What's the definition of stuff?
Yeah, everything in your personal name. So the will control everything that's in your personal name at the time you pass away. What's in your personal name? Your house, your accounts, any asset that you have. If you have a boat, if you have a car, if you have life insurance, if you have retirement accounts, will control all of the stuff that is in your personal name when you pass away.
So if I said, I want to make sure that, I don't know, my aunt's china that she has not yet given to me, but she said that she's going to give to me, I want my aunt's china to go to my daughter. Would that be something that I could control with a will?
Probably not, because it doesn't belong to you.
Right.
Yeah.
So fundamentally, it's got to include what it is that's in my possession at the time that I pass away.
Yeah,
right?
you got to have some sort of ownership. I know there's a lot of people that spend money in their head before they get it.
Yes.
And so you can't have the theoretical money that you're going to have one day leaving to somebody.
Right. Okay. So, a will is, basically it's instructions, but does a will have to have anybody who's witnessing it? Is that required in the state of Wisconsin?
It certainly is. Yes, a will is required to be witnessed by two people that are not in any which way benefiting from that will. You don't want to make the argument that they put a gun to your head and say, give me all your stuff and I'm going to witness it and then my spouse is going to witness it because everything's going to us. No, it's got to be two disconnected people and they have to watch you signing it. And now we get this question all the time. What if someone has a disability? What if someone has an issue with signing? Can I just sign an X? What's the answer?
The answer is yes. If the person who is witnessing it believes that that person is competent and capable, the legal term has capacity to sign that will, they can do so. And in fact, there's cases where somebody may be out of their mind for whatever reason, but then if they come back and they appear lucid at the time that they are signing the document and they understand the object of their bounty. That's a legal phrase that means that you understand who you would naturally be giving this stuff to and it coordinates with that, then they're capable of signing, no problem.
Outstanding, yeah. And so that's the requirement for a will. But really what a will is, if you boil it down, a will is a letter to the judge that says, when I pass away and there's a probate, here's how I want my probate to be administered. It's almost a letter that says, here are how I would like to sue myself upon my own passing.
Interesting way of looking
Yeah,
at it, but
kind of.
that's absolutely right.
Yeah, and so because as we've discussed in other videos, wills have to go through probate. If something's in your personal name, in order for that to get transferred over, it has to go through a probate. And so a will is just a letter to the judge stating, here's how I want my probate to go.
And the judge has the ability to interpret that letter.
Right.
So they can look at that document, and first of all, they have to decide whether it's a valid will or not. And then they're basically taking on the responsibility that you're requesting of them to open up a case. And the case then helps determine, okay, who do we need to make sure that this probate gets effectuated properly? So that would require appraisals, accounting. If there's minors, then it would require guardian ad litems to be appointed. It requires all kinds of inventories and oversee of process like sale of assets, and then ultimately the distribution, taxes, end of life expenses getting paid, funeral and burial, that sort of thing, and then ultimately it gets closed down.
Yeah, exactly. And so then another question that people always ask us is a will going to cut it? Is a will enough for me? And the real question is it enough for you? What are your goals? What are your concerns? If you have goals or concerns that a trust can address, no, a will is not going to be enough. But if you're not really concerned about much, maybe you don't have much, or maybe you have a ton and you really don't care, maybe you don't have kids, maybe you don't have a house, maybe you don't have the typical assets that people want to protect, then maybe a will is just enough for you, but it really all depends on what you want to get accomplished.
Have you heard people say, well, it doesn't matter, I'm going to be dead anyway, why would I care?
Yes, my favorite response to that is, why don't you love your children?
Well, what if they don't have children, though?
Why don't you love the people you leave behind? What kind of a legacy are you looking to leave? Are you looking to leave a wake of love and of joy, and making it so that people can really benefit from your largesse? Or are you looking to leave a wake of sadness and anger and all that? It's just the question you have to ask yourself. If you really don't care, great. You don't care, how am I supposed to care for you?
Yeah.
So my philosophy is always, if you don't care, great. That's fine. We'll get you a lovely will, get you out of here.
Well, I mean, they must care a little bit if they're getting a will.
Right, at least.
They're caring somewhat if they're getting a will, so that's good. It's more like not doing anything at all is pretty much, then you're really leaving it up to just whoever decides that they're going to pick up the pieces. And if you don't indicate who that is, that's going to be even in charge of picking up the pieces and moving them on to the individuals that would inherit, then that's it. So in that instance, the intestacy laws apply. And interestingly, if I were to pass away and I did not have any husband or children, then do you know who inherits next? If I don't leave a will?
Well, your folks aren't around.
My parents,
right.
Yes, and if my parents are passed
your
away,
siblings, right?
then it would be my siblings.
Is that what you want?
I have to admit, most people, including myself, would not necessarily want that.
I wouldn't want that either.
Right, so that's what you have to think about. And because if you love your nieces and nephews more than you love your siblings, you may want to consider doing that. Or if you love that charity more than you love your siblings,
right,
or their children, then that's a real opportunity that you have to direct those funds differently. So
exactly. No, that's a really good point. You wanna make sure that things go where you want, but the real question is, do I need a will? Do I just need a will? Everybody needs at least a will, but the question is, do I just need a will? That's all very fact intensive, and so it all depends really on what you're looking to protect.
Yeah, I agree. I think that at the very least, it is a very good idea to have a will. And of course, also power of attorney for healthcare and finances, because if you don't have those in place, then who is there to make those decisions for you while you are alive? So that also becomes another issue. So we tend to do all three at once. Power of attorney for healthcare, power of attorney for finances, and that will, to at least get somebody settled in those documents, and then if they decide later on that they want to add on, they certainly can. But those seem to be at least the minimum required, unless you live in an apartment and you don't have any assets at all, and the bank account is payable on death to parents, that sort of thing.
Right, like if you're let's say you're like a single person in their 20s or 30s, no kids, you're renting, the only thing you have is a mountain of student loan debt, and everything is payable on death to your parents. Yeah, you could probably get away with a will. Will's probably fine. But the moment any of those scenarios change, the moment you buy a house or maybe have a family or have a relationship or want something different, it might be a good idea to explore a trust.
Yes, I agree. And it's not so much how old somebody is as how much money they have.
Mm-hmm.
So we've had several clients come through who are in their 20s who are millionaires, even teenagers who are millionaires, and because of the fact that they have a lot of money, more than, say, the typical person in their age range, doesn't mean, oh, I'm too young to have a trust. That's not a thing. It's really, how much do I have in assets?
Was it all crypto? How they make all their money?
Yeah, one client, yes.
One of those crypto bros?
Interesting things. It's like, oh, I sold these apps.
Oh.
And then I made all this money, or sometimes it's sports cards, trading cards are very hot, and that also is something that people have made a lot of money off of. Or of course now with AI, there's going to be a whole new crop of kids that understand that far better than I do, and will probably be able to make good money off of that. So in any event, I think, is a will enough it really turns on the question of what are your assets, and then what do you care about in terms of who would get those. Because I'd say even if you have like a bike and a cat and a small bank account, but you really care that those assets would go to somebody that you're, say, living with, a significant other that you're living with, then you would want to have a will in place.
Totally.
So, all right. Anything else that you want to add about that? Well, thank you so much for joining us for this, because we are really here to protect your today and your tomorrow, and we will see you next time.